Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with a buyer going binding with a seller with a due diligence period versus a right to request repairs. Dana, what are you talking about? I thought a buyer could request repairs if they have due diligence. Well, it depends on how the buyer and the seller go under contract and what contract forms the parties use. So let's get into this a little bit. This is specific to the GAR contract forms because these exhibits are available in the GAR purchase and sale agreement, the difference that I'm going to talk about. So let's talk about a due diligence period because that is the majority of the contracts that we see nowadays. So when a buyer and a seller go binding and they agree that a buyer has a due diligence period, what that means, that is only the option for the buyer to terminate prior to the end of that period and send notice of termination to the seller prior to the end of that period for any or no reason. That's all it is. It is strictly termination rights for a buyer within that period. We used to call it a free look. That's all it is. Now, in order for a buyer to make the decision if they're going to terminate or stay in the contract, there's all kinds of things that a buyer may do. One of those things that a buyer may do to help them make the decision to terminate or stay in contract is to have the property inspected by an independent home inspector of their choice, by a termite company of their choice, roof inspector of their choice, so forth and so on, and ask the seller if the seller would address some issues. Depending on the seller's response, that again is only to help the buyer determine if they're going to terminate or if they're going to continue with that. In that time frame, the seller has an incentive to perhaps address some issues with the property, but not the obligation. It's an incentive to keep that buyer in contract because that's the contract they chose. That's what a due diligence period is. Now, in the GAR contract forms, there is another option that a buyer and a seller could go binding on a contract. That is making the contract subject to the buyer's right to request repairs. If a buyer does that, there is no due diligence period. It's one or the other. You may not have both. So, if a buyer wants to go under contract with the right to request repairs, or if the seller wants to go under contract with a buyer with the right to request repairs rather than a due diligence period, then the parties would need to make the contract subject to that. And in essence, you would use the following forms. So let me talk a little bit about what that's about, and then I'll address the forms. Again, you can't have it both ways. A buyer may not have a due diligence period or let me take it back. A contract cannot be subject to due diligence and the specific right to request repairs. There are two separate issues in the GAR contract package. I've already addressed asking the seller to address concerns with the property and due diligence, but that's not what this is. If the parties go binding and there is a right to request repairs, then in that instance, the buyer is obligated basically to have independent home inspections of the property. Then the buyer sends an amendment to the seller requesting specific repairs, and you must include the inspection report. Then there's a time frame within which the buyer can send this amendment to request repairs along with the inspection report. And then there is a time frame to negotiate through those requests. If the seller agrees, then the parties go on to closing. The buyer may not terminate for any or no reason. It's specific to the repairs. If the buyer and seller do not agree, then the buyer has the option to accept the property as is, meaning the seller will not perform any repairs, or the buyer may terminate. So The biggest difference is under due diligence, a buyer may terminate for any or no reason and does not have to state that reason. In this instance, there is no due diligence period, and it is specific to repairs requested. So now let's actually take a look at the document. So basically, it is property sold. It is GAR Exhibit 273. Property sold with right to request repairs. And what it states is the buyer shall have the right that the seller repair and or replace defects, if any, in a property identified by the buyer's inspectors in a written report within X number of days from binding agreement date. Buyers shall provide the seller with a signed amendment to this agreement requesting the defects to be repaired or replaced, and B, a copy of all the reports of inspectors describing what those defects are. If the buyer does not produce this amendment and send those reports to the seller within that time frame, then the buyer is deemed to have accepted the property as is. However, if the buyer does timely submit that written amendment requesting the repairs along with the accompanying reports, the buyer and the seller have so many days, you negotiate X number of days from the binding agreement date, and that is now going to be called the defect resolution period, to attempt to negotiate through those defects to be repaired and or replaced. If the requirements haven't occurred before, so if buyer and seller don't agree on an amendment before the end of this defect resolution period, then within 1 day after the end of that period, the buyer or seller may accept in writing the last written offer or counter offer addressing these repairs and or replacements. Or the buyer may accept the property as is. If neither of these happens, then the agreement does terminate. And then this amendment goes on describing if the inspector does in the report require additional inspection or evaluation. And it also states that there is nothing requiring the seller to replace a defect if that defect can actually be repaired. Then the exhibit goes on to define inspector and defects. So that would be the exhibit that the parties go binding under. And then for the amendment, that is GAR Form F722, Amendment to Remove Inspection Contingency Amendment, not to be used with a contract that's subject to due diligence. Again, this is not a due diligence period. And in this amendment, it states that the right to request repair contingency set forth in that exhibit is hereby deleted, and now the seller agrees to repair or replace in a good and workmanlike manner the following defects on or in the property prior to the closing date set forth in the agreement. So those would be the two forms that a buyer that you would use in a contract if you are making a contract subject to the right to request inspection versus due diligence. Now, if that's what the parties decide to do, in the due diligence paragraph, in the purchase and sale agreement, in the due diligence paragraph, you would put 0 days due diligence because you are not making contracts subject to due diligence. And then in the exhibits, you would reference that exhibit 273, property sold with right to request repairs. Now, in general, regardless of if a buyer is asking a seller to address concerns with the property in a due diligence period or request repairs in a property sold with that right to request repairs, you absolutely want to make sure that at the time that that a buyer is requesting those repairs, you address the consequences if the seller does not address those repairs. And this has been discussed in many previous videos. Basically, you need to address the concern that if the seller does not request repairs. giving the buyer either termination rights or having the seller pay for those issues to a vendor from the seller's proceeds at closing, or escrowing money, so forth and so on. And again, these special stipulations that have been written for us by attorneys or are special stipulations from the GAR or the RE forms, contract forms, are available to Maximum One agents in the reference section of Paperless Pipeline. And I believe I have linked that in previous videos. So definitely want to make sure that you address that, and also make sure that any repair issues that do get negotiated between a buyer and a seller, that you make sure to add the verbiage that this provision or these provisions shall survive closing, because under the GAR contract form, Georgia Association of REALTORS, repair issues in and of themselves do not survive the closing. So take a look at those exhibits. That one exhibit and the amendment. And if you are a buyer or a seller, that may be more appropriate to your situation in any one particular transaction. Buyers basically get, like what I say, the free look under due diligence period, but in the right to request repairs, a seller only has to address repairs, and if they are addressed, there's no termination, at least no agreed upon contingency to terminate other than what that had been addressed. If you've been practicing real estate for over 25 years, then you will remember that our purchase and sale agreements used to only have this right to request repair, this whole inspection work through period. We never had a due diligence period for residential real estate. That was a provision that I believe had first been introduced in commercial real estate, and then came about in residential real estate more predominantly during our big foreclosure market in the early 2000s. But that is still available to you. And like I said, if you've been practicing for a long time, that is the way we used to do every residential contract. So take a look at those forms. I hope this contract tip helped you out and gave you some ideas on negotiating contracts, whether you were representing a buyer or a seller. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.